Hi, I'm Stuart Solwin. I'm a criminal defense attorney here in Arizona, and in this video I'll be discussing 5 of the top DUI defenses that can get a DUI charge lowered or dismissed in Arizona. Some of these defenses can be used to attack the state's evidence at trial. Others can result in a judge throwing out essentially all of the state's evidence, and some can even result in a judge dismissing the charges entirely. Starting out with number 5, we have inaccurate breath test readings. In Arizona, a person's blood alcohol content is measured by the police for the purposes of DUI in one of 2 ways, either through a blood draw or through a breath test. A device called the Intoxilyzer 8000 is the official breath testing device in Arizona. The Intoxilyzer measures the alcohol in a person's breath by using an infrared light source to detect the alcohol molecules that are in the person's breath as the person blows into the device. However, numerous errors can occur during a breath test that can skew the result and make the reading inaccurate. This can include errors caused by radio frequency interference, which is given off by cell phones, mistakes in the police officer's operation of the machine, errors caused by the subject hyperventilating, having a high body temperature, or abnormal lung physiology, among other factors. In addition to specific errors, the Intoxilyzer itself is subject to a plus or minus 10% margin of error. So if you get a breath measurement from the Intoxilyzer, that could be 10% off. All of these considerations can be taken into account at trial and discussed by an expert witness to help show that the state can't prove the breath test results beyond a reasonable doubt. Number 4, improper administration of the field sobriety tests. The National Highway Traffic Safety Administration has developed standardized field sobriety tests that police use during a DUI investigation to gather evidence of alcohol impairment. These tests include things like the walk and turn, where a subject is asked to walk in a straight line, turn around and walk back, or the one-leg stand, which requires the subject to balance on one leg. But problems with these tests have been identified in numerous studies. For example, a 1981 study entitled Development and Field Test of Psychophysical Tests for DWI Arrests found that the one-leg stand and walk and turn can wrongly identify sober people as being impaired if the person is over the age of 65, has back, leg, or middle ear problems, is wearing high-heeled shoes, or is 50 pounds or more overweight. Other field sobriety tests, such as the eye check test called the horizontal gaze nystagmus test, instructs the officer to perform the test in specific ways, such as by positioning the stimulus that's used in the test, such as a pen that the subject's supposed to follow with their eyes, 12 to 15 inches in front of the subject's nose, and to look for clues of impairment when the eye is positioned at particular degrees of angles in relationship to the pen. It also requires the officer to move the pen at a certain speed. Many officers may be improperly trained in how to perform this or other field sobriety tests, which require specific instructions and conditions to provide meaningful results. And if the evidence doesn't show that the officer was properly trained or that the tests were performed correctly, then the results of those tests can be doubted and can lead to an acquittal at trial. Number 3, an illegal traffic stop. This can get practically all the evidence in a DUI case thrown out by the judge, making it impossible for the state to proceed with prosecution, and almost always will result in a dismissal before any trial even needs to take place. Under the 4th Amendment to the Constitution, a person can only be pulled over if the officer pulling that person over has reasonable suspicion that the driver committed a crime or that he committed a traffic violation. A police officer cannot stop somebody at random or just on a hunch, thinking that they might be driving under the influence of alcohol. This protects everyone, in the United States from random stops by the police and the abuse of police power, which the framers of the Constitution thought was inconsistent with the operation of a free society. If an individual was stopped by a police officer and then afterwards arrested for DUI, and if it can be shown that the officer did not have a basis to believe that the person was driving under the influence of alcohol or committed a traffic violation, then the judge must, under what is called the exclusionary rule, preclude the state from presenting any evidence that was gathered by the police after that unlawful stop. In a DUI case, this will usually mean all the most relevant evidence, including the results of the chemical test that showed the driver's BAC. Without being able to show any evidence that the police gathered after the stop, the state will usually have no choice but to dismiss the charges. Number 2, no evidence of driving or actual physical control. A DUI case requires the state to show that the defendant was either driving a car or in actual physical control of the car while impaired by alcohol. Usually a police officer who pulls over a suspect of a DUI arrest can testify that he saw the person driving, but sometimes that isn't the case, and it can make the state's charges hard to prove. For example, sometimes a person who's been drinking recognizes that they're not okay to drive, and so they pull to the side of the road to sleep it off until the morning. A police officer might still approach that person under those circumstances, conduct a DUI investigation, and arrest them. The issue in cases like this comes down to whether the person was in actual physical control of the car. There's no exact definition of what this means, but it includes looking at factors such as whether the person was in the driver's seat of the car, whether the keys were in the ignition, if the car was running, if it was in drive, and so on. A good DUI attorney can take all of the surrounding circumstances and chip away at the state's evidence to support the notion that a driver was not in actual physical control of the car. And finally, number 1, violation of the right to counsel. If a judge finds that a person's right to an attorney was violated, this will result in a complete dismissal of the DUI charges. A criminal defendant has the right to an attorney. The Arizona Supreme Court has found that this right is so important that the appropriate remedy when police violate it is a dismissal of the case. This was decided in the Arizona Supreme Court case of State v. Holland. In that case, Robert Holland was arrested for a DUI. During questioning, the defendant was allowed to call his attorney and leave a message with his attorney's answering service. About 15 minutes later, Mr. Holland's attorney called him back, and Mr. Holland was allowed to speak with his attorney. But the police officer who was questioning Holland refused to leave the room so that he could have a private conversation. The Supreme Court found that the right to counsel includes the right to a private conversation with counsel, and that a person always has this right. The court wrote, "Because we value the right to counsel so highly, when the right to counsel is violated, then the conviction obtained as a direct result must be set aside." If you're facing DUI charges, we'd like to see if some of these defenses can apply to your case. No attorney can promise a specific outcome, but we've worked with clients to get their DUI charges reduced or dismissed, and we'd like to see if we can do the same for you. We offer free consultations for people charged with DUI, so give us a call today to see how we can help you. Thanks for watching.